compliance in China in 15 minutes. I'm going to fall just short of that goal, but I think if I focus on four areas. Is that loud enough? Can you hear me in the back of the room? No? How about that? So as I was saying, I have 15 minutes to tell you everything you need to know about FCPA compliance in China. If I focus on 4 areas, I think I might make some inroads in at least taking some of the mystery out of FCPA compliance for you. So first and foremost, what is it? What is the FCPA? Why is it important to you? Why should it be important to you and your company? What are 3 things that you should take away from this presentation? And what are 3 things that you can do as a practical matter to limit that FCPA risk that you may well contend with in China? First of all, what is it? It is a U.S. law that makes it a crime to offer anything of value to a foreign official for a business advantage. In short, it targets bribes, corrupt payments for a business advantage. There are a host of technical definitions that relate to the FCPA. I'm not going to bore you with those, but suffice to say, that captures what the law is going after. It has 2 provisions. It has an anti-bribery provision, and it has an accounting or books and records provision. The accounting provision only applies to publicly traded companies, U.S. issuers. The anti-bribery provision applies to anyone. It has sweeping jurisdictional breadth. And when I say that, the DOJ, the Department of Justice, and the SEC have brought charges under the FCPA on nothing more than the jurisdictional basis derived from a single email routed through a U.S. server or a foreign transaction that happened to have been routed through a U.S. bank. But what I really want to convey on this slide is that it is no longer just the FCPA that you must contend with. You hear about the FCPA every morning. It's in the Wall Street Journal. It's a very hot topic. But truth be told, it is quickly being accompanied by a global anti-corruption regime that is comprised of not only the U.S. FCPA, but the U.S. Travel Act, which targets private sector bribery. It is accompanied by the new China Anti-Bribery Act, the new Brazil Anti-Bribery Act, the German Bribery Act, and the UK bribery act. So all of those coalesce, and companies now must not only contend with FCPA, but all of those. And I'm sure we've all read about the China Anti-Bribery Act. It's most recently been in the papers concerning GlaxoSmithKline, where the China law targets not only the recipients of the bribe, it targets those who paid the bribe. And there were, I believe, 21 employees from GlaxoSmithKline who have been detained in China pending their investigation relating to alleged bribes. So why is it important to you? Or why should it be important to you? It should be important if your company is considering expanding into the international arena. It is important if you're looking at foreign acquisitions. It is important if you're considering a joint venture in the international arena. It is certainly important if you're considering any type of activity in the emerging markets, Brazil, Russia, India, China, Mexico as well. But it's most important for you because it is really not about just legal risk. It is very much about deal risk. And I'm going to get into that in a moment, but it affects the deal risk in very significant ways. It affects valuation, or it can affect valuation, and it has sweeping fines and penalties which can eviscerate what was once a promising deal. It's also important to you because it really hurts the wallet. Corporate fines per violation, $2 million per corrupt payment. On the books and records, it's $25 million per accounting violation. And I'll just tie up how those interlocking provisions work. If you're a U.S. issuer, and to use a new term I just learned, if you have a woofie in China, and that woofie has an employee who's making corrupt payments to a state official to win contracts, not only is it $2 million per payment, and it doesn't matter how much the payment is. It could be a nominal value. Generally isn't, but it has no threshold. $2 million per payment plus $25 million per accounting violation. And the accounting violation kicks in as follows. Unless those bribe payments, as silly as this may seem, unless those bribe payments are booked as bribe payments, there's an automatic accounting violation. So instead of the $2 million, you're looking at $27 million per violation. So you can do the math.
So you just put a line item like bribes.
Exactly.
And then
In fact, there are actually some cases in Germany where they have line items that have the German word for bribe there. And they avoid accounting. So, three takeaways. If you don't take away anything else, take away these 3 points from this presentation. The first is, and they all three relate to deal risk. The first is the concept of successor liability. What does that mean? It means that if you acquire a target in China, once that deal closes, you own everything about that target, warts and all. You own its past conduct, including the conduct that unfolded before you even considered that target as an acquisition. And it means that you're liable, that you take on the liability for that misconduct that may have occurred. Very important concept. A corollary of that is parent-subsidiary liability, or I'll say parent-woofy liability. The U.S. enforcement authorities are increasingly aggressive with these theories of parental liability. So keep that in mind as well. The second takeaway is the business justification. If the revenue assumptions driving the deal, and in fact they are being driven by revenue, if they're predicated on corrupt payments for contracts, your target is you're not only going to have the successor liability issues, you'll also have an overvaluation problem. A relatively recent case in point involved Yolandi International, where they acquired Latin Node for $26 million. Soon after closing, they discovered FCPA issues, corrupt payments, in the amount of $2.2 million. Within a year, Latin Node became insolvent, and Yolandi had disclosed that they'd overpaid by approximately $20 million for the deal. Third takeaway, very important. I have this discussion frequently with the business side. You cannot contract to avoid FCPA liability. Reps and warranties have their place. They are important. They should be included in your service agreements and in your agreements generally. But their limit is well defined. You cannot avoid FCPA liability with U.S. enforcement authorities because you had a rep and warranty concerning FCPA. What it gives you is contractual recourse with a seller who hopefully still has some pockets. That's what it gives you. But it does not allow you, does not absolve your liability as far as U.S. enforcement authorities are concerned. Quick example, ABM acquired Link Group in 2010 for $300 million. They shortly thereafter, after closing, they discovered FCPA issues. There was an immediate reduction in the value of the merger. Disclosures occurred, and it turned out in their merger agreement they had a, quote, bulletproof anti-corruption provision. Again, it may give them recourse with Link Group, but it does not absolve them with the U.S. enforcement authorities, and it's still ongoing as far as I know. The internal investigation continues. So those 3 points, successor liability, the business justification, and the contract limitations, all very important, all go back to the fact that this is about deal risk, not just legal risk. Let me give you just a sense quickly of how one might define FCPA/anti-corruption risk. These are some of the preliminary considerations that come into play before you get to your specific business and your specific business operations. The first is regional risk. Then there's industry risk, business model risk, and the specific deal risk. And very quickly, regional risk is simply key to what's called the Corruption Perceptions Index. It's a nonprofit that literally ranks all 182 countries. At the top, I believe, is New Zealand most recently. At the bottom is Somalia. U.S. is 24 for a frame of reference. The BRIC countries fall in the band of 73 to 143, which is considered relatively high risk. And of course, that's where all the action is. That's where everybody wants to play in the emerging markets. Industry risk, so that's the data point. Industry risk. There are some industries that are historically the subject of FCPA sweeps: manufacturing, oil and gas, pharma, defense, aerospace. Just because your business doesn't fall under that industry doesn't mean that there's no FCPA risk. It just means on that particular factor, it's not high risk in your analysis. Business model risk. If your company relies heavily on third parties, agents and distributors, or relies significantly on licensing and permitting, or has a lot of government customers, that's a high-risk area that has to be assessed and incorporated into your risk analysis. And of course, the type of deal. If you're talking about buying a warehouse in Switzerland, you're probably not going to have any anti-corruption due diligence. If you're talking about a target in China that has contracts, employees, you're going to have to incorporate that into your analysis. So that really is what drives some of the major factors in risk assessment. China. Look, every emerging market, every region has its own challenges. China's no exception. Some of the more notable challenges there revolve around third parties. As you may know, third-party joint ventures, partners, consultants, sales agents are instrumental in developing and growing your business in China. They also have risk to them. Who are they? How much are you paying them? What value are they delivering? How is that value documented? Those are all preliminary inquiries that are questions you should ask and be prepared to answer. State-owned enterprises, a substantial portion of China's economy. Employees and representatives are considered officials under the FCPA. I don't want to emphasize that because there's so many statutes out there now that that becomes a less important point. But technically under the FCPA, they are officials. And the challenge in China that I found, I think many have found, is that it's often very difficult to decipher whether a particular entity does in fact have any state ownership. Is it truly private? What level of state ownership is there? It can be murky. And as can the gift giving. As you know, an important piece in business customs in China, cultural and social significance. It also can complicate an FCPA analysis, and that's something to keep in mind. So, what are 3 things you and your company can do, as of today, practical measures you might take to begin to limit this risk, to begin to assimilate it? The first thing is incorporate an FCPA risk analysis in any cross-border deal that you're looking at. And again, if it's the warehouse in Switzerland, it's going to be a quick show. But if it's something in a more high-risk area and the deal's more complicated, then it's going to involve some thinking and some planning. So that's the most important point. Second, have an FCPA compliance policy in place. And I run into this all the time. Every company, it seems, has an FCPA compliance policy somewhere. And back to David's point about the policies and procedures in the trade secret context, it's the same problem. You can't just have an FCPA compliance policy and stick it in the CEO's desk drawer. It needs to be backed up. And it's the first thing that enforcement authorities look for. So if you check the box and you've got the compliance policy, that's good. But if that's it, it's probably worse than not having one at all. Because the third recommendation I have for you is you have to have crafted meaningful internal controls that correspond with your policy and back up what you say in your policy. Otherwise, it's a worthless effort. Examples of internal controls: if your business relies on third-party agents or consultants, you need to do the due diligence and understand who those third parties are. Are they being paid in line with industry standards? What value are they delivering? How is that documented? If somebody 2 years down the road is questioning a particular consultant, you have to be able to provide that documentation to make your life easy. So those are the 3 things you really ought to consider doing, and they are relatively easy to do, and they're proportional. If you're at a Fortune 100, then it's going to be a different endeavor than if you're at a startup. So keep that in mind. Just to recap some points, it is a global anti-corruption regime. It is not strictly the FCPA anymore. FCPA due diligence is about deal risk, not legal risk, successor liability, deal valuation. You cannot contract around that liability. The reps and warranties give you contractual recourse, and that's pretty much it. Timing, in any significant deal where you're going to have to incorporate an anti-corruption layer to the due diligence, it behooves you to begin as early as possible. It does not make sense to start that process at the 11th hour and have the deal tanked on a timing issue. Avoid a scorched earth approach, particularly to internal controls. There's no need to be heavy-handed. The internal controls have to be crafted to your operations, and they have to be meaningful to what it is you're doing overseas. And finally, I leave you with this. Any company entering China or other emerging market without considering the need for anti-corruption due diligence does so at great financial and reputational risk. It is something that just can no longer be avoided. It's It's something that you must consider if you're going to do business in China or elsewhere. I thank you for your time, and I will say this, I know we're on somewhat of a tight time frame. I'd be more than happy to speak with any of you this afternoon about any issues you have or questions you have about anti-corruption. I welcome the opportunity, and I thank you for your time.